The question is about venue hire. So a particular individual enters into an agreement with a venue. The agreement is for a period of about 4 months. The agreement stipulates that there is a termination period, that's about 2 weeks. And then it so happens that in the first month of the operation of this written contract and agreement now, that the venue itself unilaterally terminates the agreement without abiding by that cancellation period, or at least notice period. The tenant in this particular matter has now already invested quite a considerable amount of funds into the upgrade of this particular facility, the venue itself. So they now face the prospect of being out on the street after having spent a lot of money. I think the question now also is around the fact that the contract itself refers to a resolution where there is a disagreement between the parties being reached in terms of a resolution being reached. The tenant says a resolution was reached on a particular matter, which I'll not discuss now, but that still after the resolution of this particular dispute, the venue itself then again unilaterally, terminates the agreement. I think the tenant here wants to know what legal recourse do they have? Is specific performance something that they can rely on? And can they potentially pursue damages in this particular matter for what is allegedly a breach of contract? Bruno?
Sure. Christopher, tell me, has the client here or the viewer here taken occupation or control or possession over the venue?
Yes, that is correct.
Yes. Okay. All right. So I've got a reason for asking that. To try and tie it into your normal conversations that we have around rentals. This is slightly different. So we do need to bear that in mind. There's some rules that don't typically apply over here, especially when it comes to venue hires, because my understanding of this would be that this isn't residential in nature. So this would be commercial in nature. Am I correct, Chris? Yeah. So already a lot of the conversations that we typically have around the Rental Housing Act and those sort of regulations and rules wouldn't apply here. So over here we're dealing more with the commercial space. Now, rentals, leases versus venue hires, quite interesting. There's a lot of similarities and there's a lot of differences with it. So the contract would be crucial here. We don't have as much legislation, as much rules governing how these contracts should look like, the same way that we do with residential spaces. And the importance of that is a lot more detail needs to go into the contract and how the parties actually wish to engage with each other. We've only got the common law and case law that kind of guide us on how certain things should work, but typically the wording of the contract would be crucial. And so there's a lot of detail in how this would have to be approached. So from what Chris said, it's basically a 4-month lease, hire, venue hire, whatever you want to call it, for a period of 4 months. There's a cancellation term, right? So all this means for our viewers is somewhere within this 4 months, there would be some level of entitlement, be it one party or both parties, to cancel this 4-month period, to cancel the lease or hire due to some reason. Now we start speculating, and this is where the problem comes in. What could those reasons be? So in practice, for example, we'll find that parties negotiate towards this because if they see in the first month or 2 months something happened, they're not getting in the type of business or people that they need to get in, they buy themselves an exit clause that just give a little bit of time for the landlord to find somebody else, or vice versa. Maybe the landlord was able to rent this out at a cheaper price because he had no one else, but the landlord wants to keep it open, the opportunity open for him to find somebody that's willing to pay more. There's a variety of reasons why people plug in exit clauses. Other typical exit clauses that you find in contracts is if the actions of the tenant make the landlord feel uncomfortable. So whatever the case is, lighting fires inside the venue could be something that's specifically prohibited. And instead of going through a whole rigmarole of please remedy your breach within 7 days, failing which I cancel. You can have terms in a contract that says, well, you know what, I'm allowed to terminate because certain things happen. These factual circumstances allowed me to summarily terminate. So that kind of covers where the termination sphere comes in. So the first question we need to look at is, was this carried out the right way? Was the landlord actually entitled to cancel unilaterally? Because some of these cancellation clauses are unilateral to a certain degree, just upon the happening of a certain event. So it's not to say that unilateral termination of a contract is wrong. It's to say that have all the tick boxes been ticked? Have all the boxes been ticked in order for this termination to actually have valid legal force and effect? So that's now the thing that needs to be borne in mind, right? Especially since there is an exit clause. Then a dispute resolution clause. So that's typically a different thing, and we don't want to wrap it all up into one ball, because the problem is, if there is a valid exit clause or a valid termination clause that only requires the happening of a certain event, the dispute over some other underlying issue doesn't really play a part in this, unless the dispute is about whether that event actually took place, whether the fire was lit at the venue, or whatever the case is. Dispute clauses are normally drafted in a way that it's typically what I said. You have 7 days to remedy. That's always the start of the kind of a dispute breach clause. You have 7 days to remedy. It affords people the opportunity to do something to fix it. Then after that, if there's any dispute that arises in terms of this agreement, there's ways that we're going to engage each other. We're going to negotiate, we're going to mediate, we're going to arbitrate, whatever the case is, right? If there's a dispute that arises relating to this agreement. So now, if there's a dispute that arises that's separate from a person's entitlement to terminate, they're not really going to impact each other. If it's about the same thing, that's now a very different story. Because can you cancel or terminate the agreement if there's a pending dispute? Typically not, because that's what the dispute clause is there for, is try to resolve the dispute before you terminate. But it would have to be the dispute that underpins the termination, because something completely separate wouldn't tie those two in. That's a shorter answer than it actually deserves.
No, but thank you, Bruno. Really appreciate that.